5 of 2021, State vs. Mokgesi and 15 others.
As a please the court, I appear on behalf of the state.
Yes.
Accused in my lord, I appear for accused.
My name is Lawrence Vargas. I'm the senior counsel at the Journalist Bar. I appeared for accused number 3 and number 4, instructed by Fluxman's attorneys. And then independently, I appear for accused number 13. 13, my lord. Instructed by victim partial attorneys. And I'm assisted in that regard by advocates Zoli Zwakwe, my junior in that matter. So I'm for 3, 4, instructed by Fluxman's, and for 13. Thank you, my lord.
Is the court, my lord, I appear for accused number 2 and 12.
2 and 12.
That is so.
Thank you. Who else?
May it please the court, I appear for accused number 11, my lord. Surname is Jorgensen, initial P. As my lord pleases.
Your worship, on this paper I appear on behalf of accused number 1, and then I also received instructions from Len Docket attorneys to appear on behalf of their clients, who is accused number 9 and 10.
9 and 10.
Please the court, my lord, I appear on behalf of accused number 6. 605 Mozambique. My name is
Thank you.
Lord, my name is Jacques Peter. I appear on behalf of accused number 14.
May it please the court, my lord, I appear on behalf of accused number 15 on instructions of the Telco attorneys.
Please the court, my lord, I'm Juan Kramer. I'm appearing on behalf of accused number 60.
As it pleases the court, my lord, I appear on behalf of accused number 5. Initials are P, surname is Jagan. Thank you, my lord.
Yes, Mr. Jackson.
My lord, I set down the matter for a pre-trial. The state is ready to proceed to arrange a trial date. However, I understand that some of these individuals have not received the copy of the docket yet, since there was a change in counsel or attorneys. I also understand that at least one of the accused is going the legal aid route. I only heard that
9 and 10.
9 and 10.
Yeah.
9 and 10. And I understand from my colleague here at the left that he only received instructions as in yesterday. So,
Accused number 5, my lord.
so there is a number of accused that is new counsel, if I could call it that. And there are some accused without counsel at this stage.
Who is without counsel?
That's 5 and 6. It was going the
No,
legal aid route.
Mr. Jagan is appearing on behalf of 5.
9 and 10.
9 and 10.
9 and 10 was the paper according to my record. It appears for 9 and 10.
I
Mr.
confirm, my lord, I appear on behalf of 9 and 10 on the instructions of attorneys who appeared on behalf of 9 and 10 previously, and who instructed me to withdraw on their behalf, being their mandate has been cancelled, and 9 and 10 will now approach the legal aid board for assistance.
Unfortunately, we do not have a representative of the legal aid board here. Had I known this, I would have arranged for it. So that's the practical problems that we face at this stage.
Yes, Mr. Donation, the practice in this division is also that before a matter is postponed for trial, the state must serve a statement in terms of section 212 capital B of the Criminal Procedure Act. And I
Yes.
do not see any such statements in my file.
Yes, my lord, I did not compile one at this stage. Because of the voluminousness of this matter, I haven't drafted one.
But that is exactly the purpose of Section 212B, to make sure that trials are managed properly and not unnecessary evidence is adduced.
Yes.
That is how we try and make sure that trials such as these, which have the potential to be very lengthy trials, are curtailed and are shortened by 212 statements, so that when the trial court deals with the matter, the trial court knows exactly what the issues in dispute are.
Your Lordship will know that I was actually the prosecutor that started this whole 212B process in this division. But experience has learned, and this is not the first case of this nature that I've prosecuted, that initially people, counsel from the defense do not want to admit anything. What I did in previous cases of this nature is let the trial commence, and after a few weeks, if I see what precisely is an issue, then I issue the 212.
No, Mr. Donason, unfortunately, I do not agree with your reasoning. You cannot fail for want of trying. You have not at any stage spoken to any of the counsel seemingly about what they are going to admit and what they are going to deny, and what would the issues in dispute be during the trial. Because, I'll tell you, we have, because of backlogs, started with a process in this division at least, that some matters will be set down for a continuous role. In other words, we set the matter down for a whole term, and we dedicate the judge to the matter, and we begin the matter, and the matter runs to its end. So if we are going to have stop-starts, the state now wants to talk, the state and the defense has never spoken to each other, we will never complete the trial. So you better speak to the acting DPP, because this is a specific agreement between myself and her, that no matter will be postponed for trial in this division unless there is a 212B statement by the state. And I'm not going to deviate from it for a flimsy reason such as the one that you just gave me. Unfortunately, I can't.
As it is.
Mr. Paper, are your instructions now to withdraw on behalf of accused 9 and 10?
I confirm, my lord.
So, who is accused 9? Because I see here Mr. Manyeki is accused number 9, but then there is also in brackets the Ori group. Is Mr. Manyeki on behalf of the group?
Yes.
Companies.
Your worship, it appears that he is accused number 9 in his personal capacity,
Yes.
and is then also appearing on behalf of accused number 10,
Number
the company.
10.
And he then informed me this morning that he will apply for legal aid.
Mr. Manyeki? Do you confirm what Mr. Papers just said?
Yes, I confirm, my lord. I would also like the court to correct the I said it.
Oh, yes. What is the correct spelling?
It's M-A-N-Y-I-K-E.
K-E.
It's M-A-N-Y-I-K-E.
Oh, Manyeki. Mr. Donation, with regard to the amendment of his surname, is it just a spelling error, Doctor? Because on this it's M-A-N-Y-E-K-I.
I've got no problem with the amendment. my lord.
Thank you, Mr. Wanike. It's then so amended. Is there any date arranged at this stage?
Those counsel that I were able to speak to, we arranged for the 19th of October. A date that suits most of the counsel, at least those that I engaged.
But instead of having you individually confirm, is there anybody that has a problem with the date as proposed, the 19th of October? Nobody. What is the position of the accused?
All the accused are on bail. And I beg the Honourable Court
Even
to...
accused number 10 and number 5 and number 6, or only the natural persons, or even
Indeed, my lord.
only the natural person.
Indeed.
So, okay. So the jurist persons are 4, 5, 6, 8, and 9. Is that correct?
I just want to make sure, my lord, the accused number 5, as represented by Linda Kaya
Mm-hmm.
Mbombani, he is present. And accused number 6, represented by Michelle Mbombani, also present. These people, of course, are not on bail. They only represent these legal entities.
And then with regard to the contents of the docket, will you make the necessary arrangement to give it to either the legal aid board's representative if they appoint judicare?
Yes, my lord, what we did is we asked the different legal representatives to provide us with a 2 terabyte hard drive. And we copied everything. We will do the same for the legal aid board and whoever else needs it.
So all the documents will be given electronically?
Yeah, because it is a few 100,000 pages.
Okay. No problem. All right, the matter is then postponed to the 19th of October 2021. Mr.
I
Otis?
apologize.
Yes.
Before your lordship responds,
Yeah.
my lord, I had notified my learned friend for the state that I do intend to bring applications on behalf of my clients. Not today, my lord. I know that he has a partner and we're not in a position to do so, but I need to record it for future determination, and whether it will be these applications will be determined by the trial judge prior to the trial commencing.
Is that now accused 3, 4, and 13?
Yes, my lord. If I can divide up between the two of them, my lord, for accused 3 and 4, that's Mr. Saudi and Docket Consulting, I'm instructed by Fluxmans. My lord, the application will be premised on the basis of non-compliance with section 35(1)(c) of the Constitution, which guarantees arrested persons of the right not to be compelled to make a confession or admission that could be used as evidence against them. It's a matter of public record, my lord, that Mr. Saudi was compelled to testify before the Zondo Commission into state capture from August 2019 all the way through to and past the amendment of the regulations, my lord. The regulation, it's Regulation 11, was amended by proclamation on 28th July 2020, which then allowed the information that had been obtained, or would be obtained from the Commission to be utilized, but from a perusal of the docket and from having participated and assisted Mr. Saudi, we were aware that he was compelled to testify prior to the amendment, and when he did so, my lord, on his behalf, recorded that he would be answering all the questions, but the evidence could not be utilized against him. We are of the respectful view that the evidence was utilized.
Mr. Otis, just a minute, to understand you correctly, you say prior to him testifying at the Zondo Commission,
Yes,
you
my lord.
put that on record?
Yes, my
Okay.
lord, in front of the Deputy
Okay.
Chief Justice. It's available on YouTube and on the record, my lord. He had said to the Deputy Chief Justice that we acted for Mr. Saudi and that he would be answering all the questions, but that the answers cannot be used against him. And it was agreed and we proceeded on that basis. Even after the amendment to the regulations, we did it once again. He said we're aware that there's been a change and that we recorded that he had been involved, and it was a continuation of his testimony. It was the third or fourth time that he was testifying on that. And we made it very, very clear that it cannot be utilized against him. And he was arrested subsequent to that, my lord, on the 30th of September 2020. That's in relation to accused 3 and 4, my lord, as instructed by Fluxmans. In relation to accused number 13, my lord, where I'm instructed by victim Kwashu attorneys and I'm assisted by my junior Mr. Zakwe. His application, my lord, is premised on the following. It will also be brought before the trial judge, or if there's a judge allocated to deal with the interlocutory applications. My lord, in that regard, his personal assistant, Ms. Chilotta, was called to the state capture inquiry that was chaired by the Deputy Chief Justice Zondo on the 18th of June 2019. In that regard, my lord, my attorney, who's the same attorney as Mr. Victor Kwashu, represented Ms. Chilotta. He was on record for her and went with her. We compiled a statement for her, and she signed the statement, which was exculpatory of accused number 13, Mr. Magashule. Thereafter, my lord, he was called to appear and presented himself, my lord, before the court on the 13th of November 2020. And at that appearance, for the first time, my lord, we were told that Ms. Chilotta is now a state witness and we're not entitled to communicate with her. And it was made one of his bail conditions. We believe that was firstly factually incorrect, my lord, because we had already had a statement from her as a defense witness and we've addressed correspondence to my learned friend in this regard, because it was placed on record both in the inquiry and in correspondence that Mr. Victor Kwashu represented Ms. Chilotta. Subsequent to that, that wasn't resolved, my lord. We brought an application for the B and C sections of the docket. The day before the application was to be heard, the state relinquished and they handed us the B and C sections of the docket. And we have had a disclosure of the first portion of the docket, and it now becomes apparent, my lord, firstly that Ms. Chilotta has never signed a statement for the state, whereas we have a signed statement from her predating her appearance before the commission, my lord, which was in June 2019. They do not, as per the docket, my lord, have a signed statement from her. So we believe that it was incorrect for the state to record that she was a state witness and to say that they're calling her when we had her as a defense witness and as authority in that regard. Additionally, my lord, it would appear...
Mr. Otis, are you therefore saying whoever gets a statement of the witness first determines the status of the witness?
There is authority for that.
That is your argument?
Yes,
Oh, that will be your argument?
Yes,
in due course.
And that, if the state wished to approach her, or if they wanted to turn her, for want of a better terminology, my lord, they ought to have spoken to Mr. Kwashu or notified him, whereas they did not do so from the period 18 June 2019 until our appearance on 13 November 2020. And even then, my lord, it would appear that she hadn't turned, because they don't have a signed statement from her, they were unable to obtain one. This is borne out by the C section of the docket, my lord, which still refers to a MLA, Mutual Legal Assistance Application, my lord, that hasn't been carried out. So the current status, my lord, is that they have drafted a statement from her, or on her behalf, I beg your pardon, they drafted a statement on her behalf, but they haven't obtained one as yet. And that was meant to be the so-called star witness. And it would appear that she isn't a witness, my lord, because she has not signed a statement to them. And there was a lot of publicity about this, and the press seemed to have got hold of her overseas where she denied it. So there was this uncertainty, but now that we have the BNC section, it has become apparent that they haven't secured her assistance, my lord. So it will be something that the trial judge will be required to decide prior to the trial as to whether, firstly, she's a compellable or a compatible witness, and then what her status is, premised on the authorities that you've cited, even in our correspondence to the state, saying that she was a defense witness prior to them. So those applications, I know that the recent authorities, and I'm supportive of them with respect, my lord, say that the trial judge should deal with these issues, but in some instances, I know in Johannesburg, by way of example, a judge is often allocated to deal with these pre-trial issues, interlocutory applications, that the matter is then certified trial ready. So our proposal with respect, my lord, would be that that be placed on record now so that we can determine together whether the trial judge or a pre-trial judge determines those issues. I know every division has a different practice in that regard, that we would obviously follow the practice of this division, my lord, for the determination of those two applications.
Yes, but it seems to me that both the applications deal with the admissibility of evidence.
Yes, Lord.
So the trial judge would, in my view, be best placed to deal with it, but we'll hear what Mr. Donation says, because ultimately, if the state, for example, will not adduce the evidence presented at the so-called State Capture Commission, then there would be no need for an application. That issue would arise with regard to accused numbers 3 and 4, not so.
No, my lord. Unfortunately, it's not that simple. From the perusal of the B and C sections, my lord, it became apparent that the only time that they began the investigation into Mr. Sodi was as on account of evidence provided at the State Capture Commission before the Deputy Chief Justice Zondo, and thereafter, with full knowledge of the fact that they were utilizing that information, they compelled Mr. Sodi to answer questions there. So he was brought before and was given the statements there. So all of that was then investigated and formed the basis of the charges against him.
Yes.
So we say to charge him, not just the admissibility, but to charge him would be unconstitutional, because well knowing that he was entitled to remain silent, they compelled him to answer there. They investigated those answers, they called for all the documents, and that's what we have in the docket here, my lord. So we say it would be incorrect to charge him. So it would be a pre-trial application to say you may not charge this person because of what you did, comparable, my lord, to an outre acquis or outre convie defense, where you've foregone your right to do so by having compelled him to appear before the commission, well knowing that you're investigating this matter, and the participation and cooperation between the Zondo Commission, for want of a better termination, and the investigators here is clear from the BNC sections, my lord.
Yes, but from what you are saying, it seems to me at this stage that the court dealing with the matter will have to listen to both the evidence. It will not just be a matter of an application, seemingly. Because if you are saying that they investigated it based on his evidence, somebody will have to come and explain that issue to the court as to whether it is indeed so, unless, of course, those facts are common cause between you and Mr. Donation. If they are common cause, then they will probably be dealt with on application.
Well, I don't believe that the common cause is the right description. They're indisputable because we have the diary, my lord.
We have the investigative diary,
Yes,
and it points indubitably to that.
Yes, my lord. They say that it's an objective fact that's determinable from the diary with respect, my lord. And that's difficult because your lordship hasn't seen.
Yeah, I don't have the docket, obviously.
Yes,
Thank you. Thank you, Mr. Mr. Donation.
As it pleases the court. My lord, with the utmost of respect, I cannot understand what we are busy with now. Is this an application? Up to few accused and convict has no applicability at this stage. Me and the investigators do not work for the Zondo Commission. Full stop. This case is not based on evidence led at the Zondo Commission. Let me put that.
So there's a dispute about that. Right.
It is, to put it very bluntly in plain English, the Zondo Commission evidence is nice to have. This case is not based, I say again, and I reiterate, is not based on evidence before the judge Zondo. That does not say that we're not going to use it, because it is in the open domain for all to know. As my colleague referred to, it is on the internet. Pertaining to this whole Charlotta issue, let me put that to bed, and I assume there will be applications in that regard. The state is dominative. We have the first entry, if I could call it that, to a witness. Whether it is for the benefit of the state or not, we have the first say. And that is unfortunately as long as the law is old. So, Mr. Lota made two statements. One, through an attorney at that stage, Mr. Magashule, which is a sworn affidavit. And thereafter she also testified under oath before the Zondo Commission. That is nothing other than a sworn affidavit. The third affidavit was drafted on her behalf by a member of the investigating team of Zondo Commission, of which we were never part. That affidavit was not signed. So indeed there is sworn evidence.
Sworn testimony.
Indeed.
So you're saying that there are affidavits and obviously the testimony at the so-called State Capture Commission.
Correct. Although my investigators did not take those statements.
Yes. All right. Thank you.
Then lastly,
Yes.
the submission that this case is built specifically pertaining to Mr. Sodi on evidence laid before the Zondo Commission, I reject with the contempt it deserves. I say again, this case is not based on what was laid before the Zondo Commission. This case is based on evidence, documentary, and by witnesses obtained by the investigators.
Thank you. Mr. Denason, I think the crucial issue now is to hear your views. Should the matter be dealt with at pre-trial stage, if I understand Mr. Hodis correctly, or will you then at the trial stage, either by way of a trial within a trial or any other means, determine the admissibility of that evidence? What is the state's view on it?
Very plain and simple, Your Lordship. I am of the view that once, for instance, Mr. Lota is before court, we can address this whole issue in a trial within a trial. And the presiding judge can decide whether she will be a defense witness or a state witness or the court's witness for that matter. But at the end of the day, her evidence will be under oath in an open court, whether on behalf of the state or the defense or as a court witness. But it's not, in all due respect, for this court to decide now.
Will you have a reply, Mr. Hodis?
Yes, my lord. My lord, dealing with the Zondo Commission, an officer of the court made a statement, my lord, that I'll show, and my own friend will be directed to C1 of the investigation diary. The very first entry refers to the evidence before the Zondo Commission. That's how the investigation began. That will be the subject of an application, my lord.
Yes,
The second aspect, my lord, with Mr. Lota, in terms of the Constitution, my lord, I know we approach this from different perspectives, my lord, the friend and I, but in terms of Section 35(3), the accused is entitled to know the case has to meet in order to prepare the matter. So it's no use saying we'll go to trial and then we'll determine the status of the witness. The accused is entitled up front to know the status of the witness. I disagree with him, my lord. So
but I think what Mr. Denason is saying is that at the trial stage, the state might use the affidavits that she made, as well as a transcript, I suppose, of a testimony before Deputy Chief Justice, or now Acting Chief Justice Zondo. I think that is what he's saying.
Yes,
and at that stage, you would be at liberty to object to them using that evidence. But he says, well, we have an affidavit, and you confirm that, which was taken by Mr. Victor Mkwachu. You confirm that. And he says there's also the testimony at the State Capture Commission. We might use a transcript, or we are going to use a transcript of that. But isn't that ideally an issue, or those issues that should be decided by the trial judge?
By the trial judge, yes, my lord, but before the trial, the dealing of other...
Well, I don't think it's for me to determine now at what stage during the trial itself can you bring the application, because I would not like to bind my colleague at this stage, because I'm not going to do the trial. So I would not like to bind my colleague at this stage as to the stage at which he or she should listen to your objections. Ideally, I think, I know we're operating in an adversarial system, but maybe there's some room for you and the state to talk and see whether you can reach common ground on when to deal with the applications during the trial stage.
As well, my lord, I saw it, just to explain my position, I saw it as a pre-trial issue that ought to be brought to the notice of your lordship today.
I
It's
appreciate
not,
that.
Mr. Donation asked, are we bringing the application to? I answered him clearly, we're not. It's something that I do agree with your lordship. We need a directive from the trial judge if it's not determined in a pre-trial situation, that then we would place it on record at the latest before the trial judge, with the view to ascertaining when the trial judge would like it determined. Unless, of course, this division operates that we deal with all of these issues prior to the enacted and allocated. But I mean, your lordship's hands in that regard, there is a process of negotiation between us, I do agree.
Yes, well, in terms of the practice in this division, it is done on a case-by-case basis. It depends on the issues. I normally do all the pre-trials, or most of the pre-trials, and during the pre-trial stage, my task is basically to make sure that the case is managed properly, that all the issues that obviously militate against a speedy resolution of a criminal trial are sorted out. And this might be such issue, but I think with regard to Ms. Cholota, because it goes to the admissibility of that evidence, it's best for the trial judge to do that. With regard to the other issue, accused numbers 3, 4, and 13, there might be room to have that argument placed before another judge, and that judge can hear the application and determine, because what you are saying basically is all the evidence against Mr. Sodi is tainted, and therefore none of the evidence against him can be adduced in any court of law because it is tainted. So that is something else. It is more substantial, whereas the one of Ms. Cholota, the state might have other evidence and then only want to adduce Ms. Cholota's evidence too, and then the issue would arise whether Ms. Cholota should be used as a state witness or as a defense witness, and the court can then determine her status and then go on to determine the veracity of the statements that she made or otherwise.
There's only one factor that I wish to mention, if I may.
Yes, you may.
In relation to Ms. Cholota, it's important to determine her status up front, because if she is a defense witness, we're entitled to consult with her and prepare. If she's a state witness, we're not entitled. So in my respectful submission, and I will motivate it, and it can be determined in due course, not necessarily today, my lord, I believe that it's something that ought to be determined prior to the trial, so that we know exactly what the status is.
Prior to her testifying, not prior to the trial necessarily.
No, my lord.
Because it's one witness. We're dealing with one witness. And you are saying that, as a matter of fact, you have already consulted with her, maybe to a limited extent. When I say you, I include Mr. Nkwachi. To a limited extent, because Mr. Nkwachi took her statement. And therefore you say that changes her status to a defense witness. That is something that you can argue before the trial court. Yes. Yes.
Thank you.
Right. The matter is then postponed to the 19th of October 2021. All the accused are on bail except for the juristic persons, which is accused numbers 4, 5, 6, 8, and 10. All the accused are then want to be in this court again at 9 o'clock in the morning. Thank you for the journalist.
Daniel, rising court.
Oh.